Hi, I'm Dominique Pandobucci, a U.S. business and investor immigration attorney. Today, I wanted to talk to you about that USCIS memorandum that was dropped on Friday, talking about adjustment of status being discretionary. Now, that was always the case. An adjustment of status is a two-step analysis. The first step is to determine whether you qualify under the law for a green card. And the second step is this discretionary analysis to determine whether you are deserving of a green card. And usually it was pretty automatic where an officer would look at the file, see your tax returns, see that you have family here, that you've been studying, your employment history. So lots of positive factors there. No need to go in depth about this weighing of the positives and negatives, and adjustments usually were just granted because there was no need to focus on the negative factors the way this memo makes it seem. Now, I did have a case 7 years ago where it was initially denied based on discretion, just that second step, and we were able to appeal it and get it approved. So I wanted to go over a couple of the factors that the officer will look at when determining whether your green card should be approved and whether you entered as a tourist or did not renew your employment status, or perhaps were out of status at the time you filed for adjustment through a family petition. Those are just one piece of the puzzle. An officer is supposed to consider all of the positives together with all of the negatives and weigh them to make a determination of whether you're deserving of the green card. And if an officer decides that you do not deserve the green card, they actually are required to write out all of the positives, all of the negatives, and how they came to the conclusion that you should not be granted the green card, which hopefully won't be the case. But so it would be helpful for you to know which factors the officer will consider so you can start saving documents. Immigration is based on paper mostly, so that you are able to submit them in case you have to argue these factors. So first will be eligibility requirements, that you meet the requirements for the adjustment of status. That's a positive. If you don't meet them, the whole case is denied. But that's really the first step, would be denied on the first step of the analysis. The second factor would be family and community ties. So how long have you been living in the United States? And at what age did you come to the United States? Do you have family here? Do you work here? Another factor is immigration status. So did you comply with immigration laws? When you first entered the United States, were you complying with the immigration laws? That's a positive factor. On the other hand, violations of immigration status would be considered a negative. But again, just one factor of this whole analysis. Another factor that's considered is business employment and skills. Are you working? For how long have you been working? And what type of work do you do? What is your education level? And other factors listed are property, investment, and business ties in the United States. Another factor is community standing and moral character. Do you volunteer? Do you attend church? Have you donated money to a worthy cause? Do you pay your taxes? Have you cooperated with law enforcement? And lack of a criminal record is also a positive factor. So when you're looking at this discretionary analysis, just because one of those areas falls into the negative doesn't mean your case will be denied. The important thing is to document all of the positives and your contributions to the US so that you're ready in case this gets questioned. I hope this provides some answers to you, and if you have any questions, feel free to reach out to us.